Good afternoon, everyone, and a warm welcome to the UNCITRAL RCAP Symposium on navigating transparency and confidentiality in international arbitration. I would like to start by acknowledging the Ghanaian country, the traditional custodians of the land on which we gather today. We pay our respects to the elders, past, present, and emerging, and recognize their deep enduring connection to this land. We are delighted to have an exceptional lineup of speakers today who bring diverse perspectives and deep expertise in international trade and arbitration. To open our symposium, we are privileged to hear from Mrs. Aditya Kovindra, head of UNCITRAL RCAP, whose leadership and dedication have significantly advanced UNCITRAL's work throughout the Asia-Pacific region. Following her opening, we will be joined by Professor Luke Norwich, Dr. Caroline Kelly, and Mr. Nick Gallows, each contributing invaluable insights into today's discussions. After each presentation, there will be an opportunity for 1 to 2 questions. To conclude, Associate Professor Tim Huang will provide closing remarks, reflecting on today's discussions and summarizing key takeaways. Without further delay, please join me in welcoming Mrs. Aditya Kovindra to deliver the opening address for our symposium. The floor is yours.
Thank you very much. Let's see. Let me share my screen. Okay, so I hope you can see everything and hear everything clearly. So distinguished professors, speakers, and friends of UNCITRAL and UNCITRAL RCAP, greetings from the UNCITRAL Regional Center for Asia and the Pacific, or UNCITRAL RCAP in Incheon Republic of Korea. It is my great honor to deliver these opening remarks, and I am particularly delighted as this is the inaugural UNCITRAL Asia Pacific Days academic flagship event co-organized by RCAP and the University of Sydney. This event also forms part of the global UNCITRAL Days activities, comprising academic gatherings organized with universities and institutions of higher learning in Africa states, the Arabic-speaking states, and Latin America and the Caribbean, in addition to the Asia-Pacific region. The UNCITRAL Days seek to raise awareness of UNCITRAL instruments and the importance of legal harmonization amongst the bright young minds who are the next generation of legal thinkers and potential policymakers. My special thanks to UNCA for the wonderful support for UNCITRAL, including RCAP all these years, and to all the expert speakers joining today. The theme for this year's UNCITRAL Asia Pacific Days is Transparency at 10, to honor the 10th anniversary of the UNCITRAL Transparency Standards, which comprise the UNCITRAL Rules on Transparency in Treaty-Based Investor-State Arbitration, the Transparency Registry, and the United Nations Convention on Transparency in Treaty-Based Investor-State Arbitration, or the Mauritius Convention on Transparency. This event is all the more meaningful as Australia is only one of 2 jurisdictions in the region that RCAP services that has become party to the Mauritius Convention, the other being Iraq, which joined in 2021. We hope that Australia's joining and this event could inspire other jurisdictions across the Asia Pacific as well. UNCITRAL has worked throughout the years to create a favorable environment for resolving disputes arising from cross-border transactions, with the aim of developing a fair and efficient dispute resolution system. This work contributes meaningfully to the achievement of Sustainable Development Goal 16, which is the promotion of access to justice and governance in accordance with the rule of law, and furthers the development of a mature, rule-based global commercial system. In addition to international commercial arbitration, dispute settlement topics covered by UNCITRAL include international commercial mediation, online dispute resolution, and most recently, dispute resolution in the digital economy. As many of you may know, the UNCITRAL arbitration framework comprises a spectrum of legal instruments, ranging from treaties, model laws, to contractual texts for use by parties and institutions. These include, for example, the New York Convention, which is nearing universal participation with 172 state parties, with Suriname and Timor-Leste being the most recent. Also, the UNCITRAL Model Law on International Commercial Arbitration, which 93 states and 126 jurisdictions have adopted, of which over 30 jurisdictions are in the Asia Pacific. And the UNCITRAL Arbitration Rules, the 2013 version of which incorporates the UNCITRAL rules on transparency for treaty-based investor-state arbitration. The UNCITRAL arbitration framework also includes instruments assisting implementation, such as notes on organizing arbitral proceedings and recommendations to assist arbitral institutions and other interested bodies with regard to arbitration under the UNCITRAL arbitration rules. And all UNCITRAL instruments are available on the UNCITRAL website in the 6 official languages of the United Nations: Arabic, Chinese, English, French, Russian, and Spanish. Turning to the UNCITRAL transparency standards, the need to enhance transparency in investor-state dispute settlement, or ISDS, arises from its special nature, manifest in terms of its impact on public interest, as ISDS deals with, among other things, regulations with public policy implications such as environmental laws, health regulations, and natural resource laws. Moreover, public funds will ultimately be impacted as a result of the costs of arbitration, including the costs of a state's representation in ISDS and the payment of damages or compensation in case the state was held liable by the arbitral tribunal. Prior to the UNCITRAL transparency standards, there was a lack of harmonization on transparency, especially in cases where there was no provision on confidentiality in the investment treaty, no agreement by disputing parties on confidentiality or transparency, and no clear arbitral rules on the issue, leading to the arbitral tribunal exercising its discretion. The United Nations General Assembly has thus acknowledged that rules on transparency in treaty-based investor-state arbitration would contribute significantly to the establishment of a harmonized legal framework for a fair and efficient settlement of international investment disputes, increase transparency and accountability, and promote good governance. I should also point out that the transparency standards were the first successful endeavor to reform investor-state dispute settlement and pave the way for further work on ISDS reform conducted by UNCITRAL Working Group 3 since 2017 until now. Turning now to the 3 components of the UNCITRAL transparency standards. First, the UNCITRAL rules on transparency in treaty-based investor-state arbitration, which are a set of standalone procedural rules that provide for transparency and accessibility of the public to treaty-based investor-state arbitration by making information on the initiation of an investor-state arbitration publicly available, increased participation in arbitral proceedings, open hearings, and making the decisions and award of the tribunal public, while preserving the discretion of an arbitral tribunal to allow closed proceedings and restrict access to confidential and protected information in the documents. Adopted in 2013, the transparency rules came into effect on 1 April 2014 and apply in relation to disputes arising out of treaties concluded on or after that date, or future treaties, when investor-state arbitration is initiated under the UNCITRAL arbitration rules, unless the parties otherwise agree. For investment treaties concluded before 1 April 2014, the rules can also be applied if parties to treaties or parties to disputes agree to their application. The transparency rules are also available for use in investor-state arbitrations initiated under rules other than the UNCITRAL arbitration rules and in ad hoc proceedings. With the adoption of the transparency rules, a new Article 1, Paragraph 4 was added to incorporate them into the text of the UNCITRAL arbitration rules as revised in 2010. The new paragraph provides for utmost clarity in relation to the application of the transparency rules initiated under the UNCITRAL arbitration rules. In all other respects, the 2013 UNCITRAL arbitration rules remain unchanged from the 2010 revised version. The second component of the transparency standards is the transparency registry, also known as the repository, wherein information to be made freely available to the public under the transparency rules is published, a function undertaken by the Secretary General of the United Nations through the UNCITRAL Secretariat. The registry is a consolidated global database of ISDS cases, decisions, awards, and other information that may explain the outcome of the proceedings, including information on treaty-based investor-state documents and arbitrations conducted under other arbitration rules, with transparency elements similar to the UNCITRAL transparency rules. At the end of 2023, a total of 24 ISDS cases have been published by the repository, involving 14 respondents. Currently, the design of the repository is in English. Case materials are available in the languages in which the materials were sent to the repository without translation, and the operation of the repository relies entirely on voluntary contributions, with the European Union being the main donor since 2016. The third component of the UNCITRAL transparency standards is the Mauritius Convention, a multilateral instrument providing for the application of the UNCITRAL transparency rules to any investor-state arbitration based on treaties concluded before 1 April 2014, whether or not initiated under the UNCITRAL arbitration rules. Currently, there are 9 parties: Australia, Benin, Bolivia, Cameroon, Canada, Gambia, Iraq, Mauritius, and Switzerland, and 24 signatories to the convention, with the European Union becoming the most recent signatory in July 2024. Together with the rules on transparency, the Mauritius Convention on Transparency takes into account both the public interest in ISDS and the interest of the parties to resolve disputes in a fair and efficient manner. In terms of efficiency, the transparency standards can be put into effect without the need to amend the 3,000 existing bilateral investment treaties. Moreover, there is flexibility in the application as states can formulate reservations. I am pleased to report that following the adoption of the transparency standards, there is a tendency towards more transparency in investor-state dispute settlement. For example, from 2014 to 2023, the UNCITRAL transparency rules were applicable to 170 international investment agreements with an ISDS mechanism, and to disputes under a further 245 agreements to which the above states are parties, where the claimant agrees to their application. In addition, 110 international investment agreements included the rules on transparency by referring to the UNCITRAL arbitration rules, and 38 of those 110 agreements have additional provisions on transparency in case other arbitration rules apply. Moreover, 15 of the 60 international investment agreements that excluded the application of the rules on transparency nevertheless included some elements of transparency. This map unofficially illustrates the jurisdictions that have entered into international investment agreements where the rules on transparency or provisions modeled on the rules on transparency are applicable. The information on the map is derived from a non-exhaustive list of relevant investment treaties available on the UNCITRAL website. For those interested in learning more, I invite you to visit the UNCITRAL website and take our free online training courses. These currently include Introduction to UNCITRAL, including how UNCITRAL's work contributes to sustainable development, UNCITRAL text on public procurement and public-private partnerships, the UNCITRAL mediation framework, and the UNCITRAL arbitration framework, including the rules on transparency. These interactive self-paced courses are free, and participants may download an e-certificate upon completion. And they are currently available in Chinese and English, with other United Nations languages forthcoming as resources allow. Finally, I invite you to subscribe to my office's mailing list via the QR code for information on UNCITRAL developments and RCAP activities. Thank you again to the University of Sydney and UNCA for joining the 2024 UNCITRAL AP Days and Transparency at 10 celebrations. Thank you very much.
Thank you, Mrs. Comitra, for such a wonderful opening remarks. So now our next speaker is Professor Luke Norwich, a distinguished authority in international arbitration and commercial law. Professor Norwich is a practitioner and a professor of comparative and transactional business law at Sydney Law School. Professor Norwich's work has significantly shaped the field, particularly in the areas of arbitration and cross-border dispute resolution within the Asia Pacific. His presentation is titled Tensions around transparency in international arbitration, Australia and Japan in regional context. Please join me in welcoming Professor Lugnold.
Thank you very much, Emma, and everyone for joining. So big thanks to Austral for that timely introduction, and to Catalyst, our Centre for Asia Pacific Law here at the University of Sydney. So I have 20 minutes to cover 28 slides, so I'm not going to do all the slides. Instead, I'm going to focus on 3 topics and jump around. These slides are available afterwards if you need them. So the first topic I'd like to think about is some of the expectations around confidentiality, particularly in international commercial arbitration, and then some of the tensions, particularly around investor-state dispute settlement arbitration. Secondly, I'd like to segue into the discussion about the 2014 Mauritius Convention, highlighting some of the limits of that, as well as the opportunities it's provided, as introduced by our previous speaker. And then third, I'd like to talk about the ongoing ZEF against Australia ISDS arbitration claims under the ASEAN Australia New Zealand FTA. There's some interesting transparency aspects there. This first slide, this is why I'm using slides, because it shows some empirical studies done even back, the first column, the far column by Christian Uring-Uller in the 1990s, showing what respondents considered the major advantages of international commercial arbitration over cross-border litigation. And the high percentages, the highest percentages, of course, are the international enforceability of awards and agreements, particularly under the New York Convention across borders, compared to cross-border judgments even. And secondly, the neutrality of the forum, particularly the capacity of parties to choose their own arbitrators and generate a neutral as well as expert tribunal. Notice the bottom of the list are cost advantages or even speed advantages, although a bit more speed advantages are evident in the other column, which is study more of respondents from this Asian region, conducted by Shala Ali from now Hong Kong University. In the middle there, you can see confidential procedure is sort of a mid-ranked advantage perceived by respondents, users and those familiar with arbitration over litigation. And so not surprisingly, most arbitral rules impose confidentiality obligations on the parties. UNCITRAL rules is unusual because it doesn't have a general obligation of confidentiality for ad hoc arbitrations, although there is a provision around confidentiality of the awards, but not other aspects of the procedure. Other rules that exceptionally don't provide for confidentiality obligations on the party are the International Chamber of Commerce rules and the Stockholm Chamber of Commerce rules. A common feature of these rules is, interestingly, that traditionally and even now, quite a few of them cases through those organisations involve investor-state arbitrations, where one of the parties is the state, so that explains why they still have less confidentiality, i.e. more transparency. If you look to national laws, and we'll soon be hearing from our next speaker about what's been going on in more detail here, but the model law, because it's largely adopted from Australian rules rather than templates, doesn't have any provisions on confidentiality itself, but countries like New Zealand and Hong Kong, Malaysia, and Australia eventually from 2015 have automatic confidentiality associated with arbitration as an add-on. Singapore doesn't have it in legislation, but through case law. So again, model law is in addition, you have confidentiality. But despite that overall trend, there are still variations either through case law and or legislation in terms of the exceptions to confidentiality, broadly related to public interest type exceptions, the administration of justice and so on. And then even more variance in terms of whether a country also provides confidentiality as a starting principle for court-related proceedings involving arbitration. So you might have come across Singaporean and Hong Kong judgments with anonymised case names and so on, which we don't have, for example, in Australia and New Zealand. They essentially have moved away to not having confidentiality when it gets to court. Exceptionally, you can apply there for confidentiality. And then there are also some non-court jurisdictions which have not added anything around confidentiality. So those include, notably in our region, Korea and Japan. However, in Japan, for example, as in Korea, the most commonly used constitutional rules provide for confidentiality anyway if you opt into those rules. Overall, we have these expectations around confidentiality which are largely met in background arbitration laws, and in particular in most often used rules chosen by parties. But there are also tensions. And just jumping to the second point here, if you think more generally about confidentiality, you have to realise it's a somewhat double-edged sword when we're thinking about implications for reducing costs and delays, which I mentioned before is a long-standing problem in arbitration. So on the one hand, if you have a more confidential procedure in arbitration, tribunals can be more robust in their proceedings and succinct in the draftings that should reduce costs and delays. But on the other hand, if it's confidential, you know, people don't get a good sense of whether arbitrators and the lawyers are providing the best value for money, unlike other service providers. It's confidential. The good news, though, here is that because of overlap between commercial arbitration and investment treaty arbitration, which has become more transparent, we can get a sense, particularly of arbitrators, whether they are providing good value for money if they're working in both fields. And the other tension is more specific to investor-state arbitration, because obviously on one side you've got states with all the public interests, extra public interests that follow from that. And accordingly, we find a new treaty practice, which we mentioned by the previous speaker, since 2014, for example, but also national arbitration laws that are adapting to allow for more transparency around investor-state arbitration. So in Australia, 2018, we had a little amendment saying, despite, since 2015, automatic confidentiality for Australian-seated arbitrations, exceptionally, this does not apply to arbitration seated in Australia when we have the UN transparency rules applying. Now, the previous speakers just talked about when those apply, and one method is, of course, here where we're talking about one member state that's ratified, like in Australia, in Asia, Australia has ratified, and, for example, as mentioned, Iraq has ratified. So if there were to be a treaty between Iraq and Australia, which I can tell you there isn't, but if they're happening, then retrospectively, those added on to that past treaty before 2014, you would have the UNCITRAL transparency rules applying under the Mauritius Convention. So if and when the Mauritius Convention is widely ratified, and not just by Australia, all its old pre-2014 treaties will gradually be retrofitted with these UNCITRAL transparency rules. But at the moment, as we saw in the Asian region, I understand Iraq is considered Central Asia, but I'm really focusing on East Asia here, including Australia, this part of the world. There have been very few ratifications. So despite this 2018 amendment to the International Arbitration Act of Australia, the UNCITRAL transparency rules are not going to apply in a lot of situations yet. And so this exception to confidentiality, otherwise in the Australian regime, won't kick in. And even if it does start to kick in as more countries ratify the convention, if Australia is, of course, the respondent state, but even maybe if Australia is the home state for the foreign investor bringing the claim. Because the treaties don't specify a seat in advance, and the parties are unlikely to agree to have Australia as a seat because it's not obviously as neutral as it could be, given that at least one of the parties from Australia. And finally, another aspect of the Mauritius Convention on Transparency rules, it doesn't apply to contract-based ISDS arbitration. That leads, and I think Nick Gallis is later going to speak a bit more about transparency in contract-based arbitrations where you've got the state on one side. Now, I'm going to jump now to thinking about why the Mauritius Convention, despite its advantages in promoting transparency and the great efforts of UNCITRAL, including this event, hasn't attracted a lot of ratifications. Outside Australia, if we leave aside Iraq, in fact, there have been none. So why is this? Now, as an academic, I can speak freely. So one hypothesis I've come up with is that perhaps we have more authoritarian regimes amongst Asian states. We might hypothesize are more worried about too much transparency about disputes where foreign investors claim against such states. And perhaps that's true, because if we look at the democracy index through the Economist, Intelligence Unit, and so on, and other measures of democracy, we have quite a few states across Asia which fall in the sort of more authoritarian end of the spectrum. And so a country I've done a lot of work with, Thailand, on these measures is identified as a flawed democracy due to the stop-start nature of military interventions and coups, military governments there. And if we look at its FTA with Australia in 2004, we don't find transparency provisions. Now, admittedly, this is an early treaty, and transparency has become much more common in later treaties. And so the result of that is, for example, the ongoing case between Kingsgate, a listed Australian company, and its Thailand in relation to the gold mine in Thailand, which expropriation by the military government, is not very public at all. I'm relying on my recent chapter with Thai colleagues mainly on public records, including ASX announcements by the Kingsgate company under Australian corporate law. Another possibility for the lack of ratifications in Asia is a more technical one I can think of, which is, we would have, it's just been explained, it applies to pre-2014 treaties. We're now 10 years on, this is seminar still race, and as more time goes on and on and on, it seems to me that the benefit of ratification declines, because what about all the treaties concluded between 2014 onwards and the time of ratification now or into the future? Now, it's true, as the previous speaker mentioned, that many treaties are anyway now referring to UNCITRAL rules, which incorporates the 2014 transparency rules. But in those treaties, they typically also, for example, include exit convention arbitration options, which actually is more preferred by foreign investors because of enforcement advantages. You don't need to go through the New York Convention to enforce the award and so on. So then to get transparency, because it's not so much in the exit conventional arbitration rules, that regime, you need to rely on whatever's built into the treaty. But if the country hasn't ratified the treaty, maybe it's not so keen on transparency. So here's a suggestion for UNCITRAL. Maybe we need a UN protocol that parties could ratify, so that the UNCITRAL transparency rules are retrofitted onto treaties from, say, 2024, and before that, not 2014. All right, that's the second topic around the Mauritius Convention. My last few minutes, I want to talk about the ZEF and Australia cases, which are starting to attract a lot of attention here, arguably in the background for why Australia has, under the current Labor government, reverted to an old policy which operated for a few years, where Australia would agree to no future treaties containing ISDS arbitration provisions. Because these are very controversial claims. They're brought by a company that is incorporated in Singapore, but it's owned by an Australian mining magnate and former federal senator, Clive Palmer. And notices of dispute have been filed. Some of them are public, at least the ones brought under the actual Singapore-Australia FTA, but claims are now being registered and the PCA, Permanent Court of Arbitration, The Hague, is the positive. So we can track these cases as they're unfolding. They brought under the ASEAN Australia New Zealand FTA, dates back to 2009. So they refer to UNCITRAL rules, and the cases are proceeded under the UNCITRAL rules, but they're the old UNCITRAL rules, not the ones that incorporate transparency. Now, fortunately, the 2009 UNCITRAL does have some transparency rules. For example, by implication, the first tribunal hearing a case about alleged expropriation and denial of justice by the Western Australian state government about an iron ore project, the tribunal in that case found that the treaty suggests that hearings should be in principle open to the public, subject to redaction of confidential information. So I had great excitement and pleasure of listening into live-streamed hearings at PCA some weeks ago, and under the transparency ruling of the tribunal, there will also be associated transcript of all those proceedings and even submissions of the Australian government on the jurisdictional objection in that case made available to us all. Couldn't stay up all night to listen to these proceedings live streamed. The other aspect of the other ZEF case that we know most about, because it is listed on the PCA website with various tribunal decisions and so on, involves challenges to measures taken by the Queensland state government around a coal project, and specifically claims that there was violations of UNCITRAL because the Queensland government, in effect, granted an environmental offset to a direct competitor of the claimant, ZEF. This is interesting because we have a somewhat overlapping tribunal membership. In their first procedural order, they suggested, incorrectly I would say with all respect, that under the old UNCITRAL Rule 25.4, hearings should be held in camera. When they got to their procedural order 3 on transparency, they corrected that and said, well, actually, indicated actually the treaty allows for open hearings, so it's not in camera. This procedural order is also interesting because it's basically, with agreement of the parties, coordinated with the first ZEF arbitral tribunal so that they can share information. So if you compare the transparency order and the second arbitration, it's almost identical as to the scope of transparency compared to the first ZEF case. So hopefully this means that the hopefully well-reasoned procedural, even substantive decisions that gets this far by the first ZEF tribunal will also influence the second tribunal on similar issues, particularly on the procedure, the jurisdictional objection that's already been heard in the first case. And so we can see some benefits of transparency also here for efficiency, because hopefully then there won't be a rehashing, a whole new set of hearings about very similar issues that have already been heard and decided upon by the first ZEF tribunal. Although I think it would be even more efficient if we had an EU-style investment court option, and I've proposed this in the ongoing work program under a new protocol to UNCITRAL. It's going to reconsider whether they should maintain ISDS in the revised treaty. But I won't have much time. I won't have much time to talk about that in detail. I'm not happy to take any questions. So I hope that's my time up enough. I think I'll leave it there. So three aspects: intentions and expectations in commercial arbitration, even, but also investor-state arbitration. Generally, a suggestion about how to make the Mauritius Convention more popular for ratifications, and then this case study of the unfolding ZEF cases, which are, thanks to the treaty, even an old treaty, quite transparent. Thank you.
Thank you, Professor Notic. Now we will have time for 1 or 2 questions, either online or in here.
Professor Notic, thank you very much for your illuminating talk. How do you see this playing out in the short term?
These tensions?
Yes.
So good question. Thank you, Dr. Yuan. I think in commercial arbitration, on balance, the expectations, the benefits of confidentiality are still strong, particularly in the Asian region, as we saw with the statistics at the very start. And so both in legislation and or actual developments, amendments to rules, I think there will be a principle of confidentiality expanded, but each speaker might have a view on this. But perhaps within rules, especially some tweaks. So, for example, there's some renewed interest in more disclosures about who the arbitrators are and how many cases they've been running and whether they've been delayed in giving awards and so on, and making that public to make the process a bit more transparent and efficient. And also there's ongoing discussion about whether effective arbitration awards should be published so that arbitrators don't need to reinvent the wheel there, and the substantive, say, contract law can develop rather than having things decided by confidential arbitration procedures, rather than in court, case law accessible to everyone to develop a substantive law. So that's commercial arbitration. Still, I think the confidentiality principle would be the starting point. But for investor-state arbitration, I think we'll see the opposite, the sort of increasing trend towards transparency. Mauritius Convention was a very ambitious multilateral convention, which a lot of states signed up to. Not so many have ratified, but it's starting. And as was also mentioned by the previous speaker, in the meantime, modern treaties do build in, like already the old 2009 UNCITRAL treaty, some aspects of transparency. Well, so I think that will continue to be the trend because of the criticisms that this essentially type of transnational administrative constitutional law type claim against host states for misbehaving towards foreign investors should be, raises a lot of public interest, and so therefore should be more open and transparent. And I don't think that's both a short-term, medium-term prognosis.
Thank you, Professor Notic. And now we're going to continue with our next speaker, Dr. Caroline Kenny, a highly respected authority in international commercial arbitration with over 35 years of experience in complex international disputes. Dr. Kenny is a chartered arbitrator, King's Counsel, and holds chambers in both Melbourne and London, bringing deep expertise across multiple jurisdictions, including Australia, the United Kingdom, and New York. Her presentation is titled Confidentiality versus Transparency. Are they mutually exclusive concepts in international commercial arbitration? Please join me in welcoming Dr. Caroline Kenny. Thank you, Emma, for that kind introduction. And thank you to RCAP for inviting me to speak this afternoon. My topic this afternoon is the tension between confidentiality and transparency in international arbitrations. I will start by examining the meaning of the concepts confidentiality and transparency and the issues they give rise to, and then conclude by looking at the reason why these tensions may explain the reason why the model law doesn't address confidentiality. So confidentiality in an international arbitration generally refers to an obligation by parties and other participants not to disclose information provided to them in the course of the arbitration, including the pleadings, witness statements, transcript, and the award, whether they have expressly agreed to do so or not. Even though confidentiality may be lost to the open justice principle when aspects of the arbitration are litigated through the courts, or when the award is being enforced or challenged at the end of an arbitration, confidentiality in international arbitration is considered by many users to be a highly valuable attribute. This is because it enables disputes to be resolved in private, and the perception is that access to documents produced for the arbitration will be limited to the immediate parties to the arbitration. The importance of confidentiality to users has been confirmed by numerous surveys since 1992, as Professor Luke Nottage noted in his address. To add to the statistics that he mentioned, the 2018 Queen Mary University of London survey reported that 87% of respondents considered confidentiality to be of importance and ranked it fifth as the key reason for choosing arbitration, and 46% of in-house counsel considered confidentiality to be one of the top 3 reasons to prefer international arbitration. So not the only reason, but certainly high up there as one of the reasons. Although the concept of confidentiality is closely aligned with the concept of privacy, they are not the same. Privacy is generally understood to mean that parties can exclude third parties from the hearing. It is widely, if not universally, accepted that international commercial arbitration is a private dispute resolution process. English law has recognised the privacy of arbitrations for centuries. And even in Australia and Sweden, which have diverged from the English position on confidentiality, they nevertheless agree that arbitration is a private process. The debate about whether confidentiality is an inherent feature of international arbitration mainly centres on whether the private nature of arbitration carries with it, or should carry with it, a corollary obligation on parties and participants to maintain the confidentiality of documents created as a result of or for the purpose of an arbitration. Perhaps the most common argument in favour of confidentiality is that if privacy is accepted as a necessary and desirable attribute of international commercial arbitration, it logically follows that confidentiality should also be accepted. The proponents of this view say that there would be little point in excluding the public from an arbitration hearing if it were open to a party to make public, for example, in the press or on television, an account of what was said in the hearing. It is difficult really to argue against the logic of that proposition. If parties choose a private dispute resolution process, they must at least impliedly not want important aspects of the dispute to be made public. Proponents of confidentiality also argue it is a reason that parties resort to private arbitration rather than the alternative of public litigation in national court. Gary Bourne, for example, has written that confidentiality encourages the efficient and dispassionate dispute resolution away from the prying eyes of the press or efforts to gain extraneous leverage. Parties may choose arbitration because of the type of dispute involved. There may be a desire to prevent the public exposure of serious allegations, such as allegations of misrepresentation,
incompetence or the lack of adequate financial means. The fact that documents produced as a result of an arbitration, such as an award, may come into the public domain after the arbitration has concluded, does not detract from the nature of arbitration as a private dispute resolution process. This is readily understandable. There is a difference between the result of an arbitration being made public by the publication of the award and the process and the documents used to obtain the award being made public. For example, in a partnership dispute, it's one thing to be made public that a former partner has left the partnership, and another for the documents prepared for the purpose of the arbitration to be revealed. Those in favour of confidentiality also argue that without a prohibition on the use of documents produced for an arbitration, parties would take advantage of the position and disclose documents for their own purposes. The potential improper use of documents would undermine the arbitral process. If the parties thought that personal or sensitive information or documents could be used outside an arbitration with impunity, they would be less likely to disclose them, and this would, in turn, impede the tribunal's factual investigation to arrive at a fair decision. So we've dealt with the concept of confidentiality. What then is the concept of transparency, and what issues does it give rise to? Transparency in the context of international arbitration refers to the availability and accessibility of information about arbitral proceedings and the capacity to participate in those proceedings. In many ways, it is the opposite of confidentiality. It is argued that greater participation by third parties enhances public understanding about the arbitration process and fortifies the integrity of the process. This includes not only decisions made in international commercial arbitration or investment arbitrations, but decisions made by institutions such as how institutions make their rules, how they address challenges to arbitrator appointments, things of that nature. At its core, the main aim of transparency is to facilitate monitoring of the decision maker, whether it's the arbitrators or an institution's decision on a challenge to the appointment of arbitrators. Some argue that the recognition of a broad-based principle of confidentiality, such as exists in England and Singapore, undermines transparency considerations because it prevents the publication of awards without the consent of the parties. The common law and statutory provisions recognise exceptions to confidentiality, of course, such as the need to enforce an award. Many arbitral institutions have followed the lead of major arbitration hubs and protect the confidentiality of the award. Even the UNCITRAL arbitration rules, which are silent on confidentiality, prevent disclosure of the award without the parties' consent. The move towards greater transparency in international arbitration has led to a debate about whether awards should be published, with opposing views being expressed on the subject. The tension between confidentiality and transparency is apparent in this debate. Those in favour of publication argue that the paucity of information about arbitrations makes the process less predictable and therefore undermines its legitimacy. It is argued that the failure to publish awards in some form limits the homogeneity of awards and inhibits the development of a uniform and autonomous international arbitration law. Those who oppose publication of awards argue that parties have selected a private dispute mechanism and confidentiality should extend to all parts of the arbitration, including to the award. This is premised on the argument that the arbitration is based on a private contract between the parties, and as such, the award should not be disclosed to the public. As we've heard previously, consideration of transparency has had the most impact in investment state arbitrations. Transparency is considered important in these disputes because they deal with wrongful behaviour by a state, and the cost of defending claims and paying awards are borne by the public. Athesa from Kaminda from UNCITRAL has mentioned the rules on transparency in treaty-based investment state arbitration, and I think I will not take up any time in mentioning them further. The final topic I wanted to address is whether the tension between transparency and confidentiality prevented the model law and arbitration rules from addressing confidentiality. As we know, the rationale for the model law was to provide a comprehensive set of guidelines to arbitration practitioners and to harmonise international arbitration law and practice. The drafters of the model law included the publication of awards and the secrecy of deliberations in the list of topics to be addressed by the model law, but not privacy and confidentiality. There may be several reasons why these topics were not addressed. First, and to a large extent, the model law reproduced the provisions of the 1976 arbitration rules. And it's possible that it could not address confidentiality because the rules were silent on the issue, except in relation to the publication of the award, which required the consent of the parties. The 1976 arbitration rules themselves were in turn based on the International Chamber of Commerce rules, the ICC, which were also then silent on confidentiality and remain silent on confidentiality. Another reason why confidentiality may not have been addressed in the model law and in the arbitration rules is that the arbitration rules are often used in investor-state arbitrations, which involve more public interest than international commercial arbitration, and there is therefore a greater concern for transparency, as we have heard from Professor Motic. A further possible reason why confidentiality was overlooked in the rules and in the model law is because there may have been an assumption that arbitration was by its nature a confidential process, and therefore there was no need to address this in any detail. In this regard, English practitioners reported that up to the 1980s, the issue of confidentiality in arbitration proceedings and in relation to documents created or disclosed in the proceedings was never debated and almost could be said to be non-existent. It was assumed that confidentiality attached not only to the proceedings but to all documents created for it or disclosed in it. This apparent underlying assumption that confidentiality was a settled principle that did not need to be provided for in the model law proved to be misplaced. When the issue first came before the English Court of Appeal in Dolling, Baker and Merritt in 1990, that and subsequent English cases confirmed that confidentiality was an implied obligation inherent in the private nature of arbitration. However, a very different position was taken by the High Court in Esso Australian Resources Limited and Plowman. The court in that case distinguished between privacy and confidentiality and found that confidentiality was not an inherent feature of Australian commercial arbitration law. In the colourful words of one commentator, the Esso and Plowman decision crashed like a giant wave, a veritable Australian tsunami on the shores of jurisdictions around the world. This is because it was the first time that a Superior Court had questioned whether confidentiality was an inherent feature of commercial arbitration. Although some institutional rules at that time included provisions of confidentiality, it was really only after Esso that national legislation began to emerge. In particular, New Zealand was one of the first jurisdictions to introduce a confidentiality regime into their international arbitration law, and really this was for the purposes of distancing themselves from the Australian position, and then subsequently Australia and Hong Kong introduced legislation. So recognising the uncertainty created by Esso and Plowman, a note issued by the UNCITRAL Secretariat in 1999 identified the issue of confidentiality as a topic for future work by UNCITRAL. The Secretariat noted that after Esso and Plowman, the expectations of some parties that arbitral proceedings were a confidential process may not be adequately protected by arbitration rules or by national arbitration laws. Confidentiality was considered to be a topic for future work by UNCITRAL in March 2000, but there was no in-depth discussion about it. The issue was again considered in 2006 in connection with the proposed revision to the UNCITRAL rules. It was noted that the rules address confidentiality of awards, but not the confidentiality of hearings or the material before a tribunal. That working group noted that the matter was complex, that there were diverse views expressed on the importance of confidentiality, and the practice and the law was still evolving. The topic was considered again in 2007. Amongst others, the working group noted that drafting a provision would be extremely problematic, and it was also argued that the inclusion of the provision would be contrary to the trend towards greater transparency, and that the law and practice in relation to confidentiality was still developing. So in summary, as a result of the controversy caused by SO, confidentiality was identified by UNCITRAL as an important topic for investigation, and it was considered by various working groups between 1999 and 2007 in connection with amendments to the model law and the arbitration rules. But ultimately, UNCITRAL decided not to prioritise confidentiality because it would be too difficult to formulate a provision, and the principle was still developing through the courts, and it would cut across the trend towards transparency. So the failure of the model law to address confidentiality has arguably led to a lack of uniformity in national laws or arbitration rules concerning confidentiality. In some jurisdictions, such as England and Singapore, the courts recognise a broad duty of confidentiality as an inherent feature of arbitration, while in others, such as Sweden, the courts have said that confidentiality is expected of participants in an arbitration, but is not a legally binding obligation. Similarly, legislation in Hong Kong and New Zealand and Scotland established comprehensive confidentiality regimes, while other jurisdictions, such as Norway, reject such a duty unless the parties expressly provide for it. There is likewise a lack of uniformity in institutional rules. Many rules impose confidentiality obligations, but the rules of the International Chamber of Commerce and the UNCITRAL arbitration rules, which are two of the most widely used rules, do not. Another anomaly is that just under 40% of jurisdictions who have adopted the model law have recognised the importance of confidentiality to users, and in the absence of a model law template to follow, have included their own add-on provisions in their arbitration legislation, but with dubious success. For example, the law of the Republic of Belarus, which established an international arbitration court, recognises that one of the principles governing the court is the confidentiality of the case's settlement, but goes no further. It seems that when UNCITRAL was considering whether to prioritise confidentiality between 1999 and 2007, it was influenced by the trend towards transparency and the difficulty of drafting a comprehensive provision. It should also be mentioned that last year the UK Law Commission considered whether to codify confidentiality in the English Arbitration Act, but ultimately decided not to do this. In this decision, the tension between confidentiality and transparency is also evident. The Act regulates domestic and international arbitrations, including non-ICSID investment arbitrations. Among the reasons given for not adopting confidentiality was the trend towards transparency. It should be, despite the tension between confidentiality and transparency, it should be recognised that confidentiality and transparency are not mutually exclusive concepts. It is possible to impose an obligation of confidentiality on participants in an arbitration and to achieve more transparency over the arbitral process, for example, the publication of redacted awards, or what they do in Singapore is to use only letters A, B, and X, Y, and Z, for example. Some leading institutions have embraced this balance between confidentiality and transparency by introducing reforms which have made the process considerably more transparent. These include the decision of the London Court of International Arbitration to publish its decisions on challenges to arbitrators, and the International Chamber of Commerce decision to publish information about arbitral appointments and to introduce an opt-out provision under which the default position is the publication of awards. It must be acknowledged, however, that many institutions are proceeding cautiously in embracing transparency provisions. The caution is reflected in SIEC's decision to partly retreat from an earlier position on the publication of awards, whereas the 2013 version of the SIEC rules permitted the SIEC to publish awards without the consent of the parties, with the names and identifying information redacted. This position was varied in the 2016 version of the rules, which permit SIEC to publish the award only with the consent of the parties and the tribunal. The 2021 version of the RCAP rules limit the disclosure of information related to an arbitration compared to other institutions. For example, they do not allow the publication of anonymised awards or decisions on challenges to arbitrators. These developments suggest that there continues to be a tension between confidentiality and transparency, albeit with the former prevailing for the time being in international commercial arbitration. Thank you very much, and I give this time for some questions. Are there any questions?
So in addition to the three possible explanations for model or not addressing confidentiality, there's a fourth that there was just diversity amongst member states' laws on this question.
It wasn't, that wasn't really a fourth reason, but what the working groups discovered and said at the time is that the concept of confidentiality was still developing, and therefore, it would not be a good reason to include it in the model law. And that's also the recent response of the UK Law Commission. And I think in relation to that, it's really a missed opportunity. As we know, like Singapore and London are now sort of on an equal par as the number one preferred states in the world. Now, Singapore has moved to actually introduce to make confidentiality part of its law, and it's done it by a simple, I think it was 2021 amendment, which simply says in the an amendment to their international arbitration law, which says the confidentiality, whether it arises from rules or from an arbitral hearings ruling, will be enforced. So it has an imprimatur of the statute. In England, the position is that you have to wade through all these cases to find out what the principle is and also what the exceptions are. And I think that if you look at the quite well-developed legislation that's in Australia, the Australian regime and the New Zealand regime, the Scottish regime is quite good as well. That the excuse that it's too hard to do it doesn't really stand up. And it would be better for everyone if confidentiality was just accepted and it was codified. So, do you have a question?
Yeah. Do you think that confidentiality is necessarily desirable, though? It seems like, given how different nations and political structures have different approaches to commercial freedoms and access to information in society, that they may not all want to or agree that confidentiality is something that we should all agree on internationally. There's also tensions with democratic principles. No?
Yeah, that's an interesting angle. What I would say to that is that I think confidentiality is desirable in international commercial arbitrations. Whether it's desirable in investment treaty arbitration is another point. But what we could do, and in fact, I think what the Australian Professor Montague won't know more about this, but I think what Australia's done is carved out the confidentiality regime when it comes to investment treaty arbitrations. But yes, I do. When parties choose to arbitrate, they're choosing a private dispute resolution process, and I think it's really accepted in most of all of the major jurisdictions that confidentiality is important to the process. And I think that what you'll see is as I said, just under 40% of jurisdictions have adopted the model law. And because there's no template provision in the model law, they come up with their own dubious legislation as an add-on provision to the model law, which actually many of them don't contain any exceptions. They don't explain how the confidentiality provision works, to whom it applies, things of that.
One more question. So, in your opinion, how flexible should the rule on confidentiality be in the perspective of third-party funding?
In the respect of what, sorry?
Third-party funding to arbitration. So how should we make it more flexible to accommodate third-party funding?
So the KICA rules provide.
Do they?
Yeah. So, the trend has been for arbitral rules to be amended because they're easier and quicker to amend than legislation, to provide a further exception which allows, in fact, requires, a disclosure of the fact of third-party funding, at least. So, if you look at the KICA rules 2021, there's a further exception added there to confidential, otherwise very broad confidentiality, so that a party can disclose fact of third-party funding.
And I should add that also Hong Kong and Singapore, about 3 years ago, they adopted rules that allow third-party funding for international commercial arbitrations, but not for litigation, and they also require the disclosure of funding.
Thank you very much, Dr. Perry. That was a wonderful presentation of the concepts. So our next speaker is Mr. Nick Gallas, a leading practitioner in law. His expertise spans both investment treaty and contractual arbitration, with teaching experience at esteemed institutions like the University of Adelaide, Monash University, and Queen's University. His presentation is titled Transparency in International Contractual Arbitration with the States. Please join me in welcoming Mr. Nick Gallas.
Thank you. Let me begin my presentation this afternoon with a couple of apologies. First of all, I apologise for not being there in person. When I accepted the invitation, I fully expected I'd be in Sydney tonight, and something unexpected came up and I couldn't be there. I'm sorry for that. My second apology arises from the fact that it is Halloween tonight. I'm at home and I'm the father of 2 young daughters. Given those factors, the chances of a small person dressed as a skeleton running into the room demanding candy is about 100%. I apologise in advance for when that happens. I'm going to actually add a third apology as I look at the screen now, because as I look at the screen, I see that 3/4 of it is taken up by an image of me, but on about a 3-second delay. So I'll do my best to present given those circumstances. With those apologies aside, let me move on to the presentation. What I want to present on tonight fits, I think, quite neatly in between the two presentations that we've had so far. We had Professor Nottage talking about transparency in investment treaty arbitration, and we had Dr. Kenny talking, amongst other things, about the importance of confidentiality in private contractual arbitration. What I want to talk about fits, in a sense, within those topics, and it's about confidentiality and transparency in contractual arbitration involving a state. I wanted to talk about that because it seems that in the debate over transparency in international arbitration involving states, the focus these days very much tends to be on investment treaties, and that, I guess, arises largely as a result of the work done by UNCITRAL and the Mauritius Convention. But I do wonder that in that debate, whether or not the issue of transparency and confidentiality of contractual arbitration involving a state gets neglected. And my modest proposal for you all tonight is that that issue does not get neglected. That proposal rests on two planks. The first plank is that arbitrations with states arising from contracts are not uncommon. And we have examples of that in the presentations that we've had tonight. Professor Nottage spoke of the first ZEF investment treaty arbitration between Clive Palmer's company and the Government of Australia. Of course, that investment treaty arbitration has its origins in a contractual arbitration between the Government of Western Australia and Clive Palmer's company. It was an arbitration that arose from an agreement between the two parties about the development of an iron ore mine in Western Australia and a dispute about whether the conditions for producing iron ore from that mine were satisfied. Let me use this hook actually as an opportunity to come back to something that Professor Nottage mentioned with regard to the ZEF arbitrations and the fact that he managed to tune into the procedural hearing that was held at The Hague a few weeks ago, although, as he said, he didn't stay up all night to follow it. It did remind me that many, many years ago, I was involved in, I think, what were the first public hearings under an investment treaty under the NAFTA. I remember at the time there was much fanfare as it was announced that these hearings would be public, and there was much concern that as a result of that the hearing would be overwhelmed with protesters. Indeed, those concerns weren't without foundation, because the issues that we'd been addressing in these disputes had been very much the centre of the public debate and had taken up lots of space in the newspapers. Having been concerned that there would be an overwhelming number of protesters disrupting the hearing, in the first half dozen or so of these hearings I was involved in, which were open to the public, we had precisely one person come to watch. That one person who came to watch, in fact, was the spouse of the lead counsel for the claimant, and I'm pretty sure that she was there at the invitation of the claimant's lead counsel rather than because she was interested in the material that we were addressing. Anyway, the ZEF arbitration is an example of a contractual arbitration involving a state that indeed was the origins of the dispute there. I can give other examples of arbitrations arising from contracts involving the state. Before returning to Adelaide, when I practice overseas, I practice almost exclusively in disputes in that area. For example, I represented an American oil company that was being sued in arbitration by a Middle Eastern country. The Middle Eastern country alleged that the US oil company, following the production of oil in that country, had failed to fulfill its obligations to clean up the area it was producing oil from. I mentioned the case as an example of an arbitration of the state arising from a contract. I also mention it because it also touches on something that Professor Nottage mentioned before. Professor Nottage mentioned how he was hoping that because of the transparency regime in place in the ZEF arbitrations, that the second ZEF tribunal would be influenced by the first ZEF tribunal. In this arbitration that I mentioned between this big US oil company and the Middle Eastern country, the Middle Eastern country went to some extraordinary lengths to prevent a second tribunal from being influenced by the first tribunal, and indeed they relied on confidentiality to do it. What happened is that the Middle East country had filed a claim in arbitration against my client, the US oil company, and had received a very unfavourable initial ruling from that first tribunal. It then constituted a second tribunal and tried to pursue the very same issue that had already been decided by the first tribunal. Of course, we argued to the second tribunal that the Middle Eastern country couldn't make this argument because it had been decided as res judicata by the first tribunal. In response, the Middle Eastern country argued that we were not allowed to raise the issue of res judicata because everything that happened in that first arbitration was confidential. That even though the parties were exactly the same, the confidentiality of the first arbitration meant that what was decided in that first arbitration couldn't be raised in the second arbitration. In other words, they were relying on confidentiality as a sword to get a second bite of the cherry. Now, as you can imagine, that argument didn't fly with the second tribunal, but it does demonstrate that whilst in the ZEF arbitrations, we're in a situation where we're trying to rely on transparency to ensure that we have consistent decisions. In other disputes, we have parties rely on confidentiality to indeed ensure that tribunals are not even aware of other tribunals, even though the parties are exactly the same. Whilst abroad, I was involved in other contractual arbitrations involving the state, involving an arbitration where there was a contract between the state, a European country, and a US aerospace company for the production of military helicopters. The US company supplied these military helicopters to the European state. One of those helicopters quickly crashed, and there was a dispute as to who was to blame. I mentioned that dispute because I'm going to come back to it in a few moments to make a separate point. The final example I'll give of arbitrations involving a state arising from a contract, some arbitrations I've been involved in since being back in Adelaide. We've been representing the government of South Australia in a series of arbitrations arising from the development of the new hospital, North Terrace, here in Adelaide. $2 billion, I think it's still the most expensive building built in the Southern Hemisphere. Unfortunately, it was defective and delayed, and there's been disputes between the builder and the state as to who's responsible for that. I'm going to also talk about that dispute a little bit in my presentation tonight. Let me point out that in doing that, I will not be breaching any confidentiality obligations. Before bringing claims in arbitration, the builder brought claims against the state with regard to that hospital before the federal court. And it was only when the federal court decided that, in fact, the arbitration clause covered the claims that the matter ended up in arbitration. So rest assured, when I talk tonight about that arbitration, I'll be referring to what was argued in the federal court and not what ended up before the arbitration tribunal. It would indeed be ironic if, when presenting at a seminar on confidentiality on arbitration, I breached my obligations in an arbitration. So the first plank on my modest proposal tonight is that their arbitrations between states and private parties arising from contracts are not uncommon. And I've given a few examples to try and make that point. Indeed, these arbitrations might become more common going forward as states increasingly embrace the idea of arbitration to resolve disputes arising out of contracts. We saw just a couple of years ago the president of Brazil issued a decree under which Brazil accepted for the first time that it would arbitrate disputes between the state and private companies in particular areas of the economy. And I do note as an aside that within that decree, there's a separate provision in which the president of decree stated that all arbitrations would be transparent. The second plank that I want to move on to tonight to support the modest proposal I'm making is that the arguments for transparency in investment treaty arbitration, many of which were touched on by Luke and by our first speaker, arguably apply equally in many arbitrations with states arising from contracts. The UN Working Group report that led to the Mauritius Convention stated the reasons for developing what became the Mauritius Convention. It stated, I'm going to quote here from the report, that a view was expressed that investor-state arbitration might involve consideration of public policy and could lead to large potential monetary liability for public treasuries. And indeed, the first speaker tonight mentioned those same two factors as being a reason for transparency in investment treaty arbitration. One, potential massive liability of the state, and two, considerations of public policy. But those two factors are going to be present in many contractual arbitrations involving the state. And I'll demonstrate that by reverting back to the examples I gave before. The ZEF arbitration that I mentioned involved a claim by Clive Palmer's companies of many billions of dollars, and it involved the clear public policy considerations of what are the conditions on the extraction of natural resources from the state of Western Australia. The helicopter arbitration that I mentioned involved a potential liability of $60 million, which was a huge potential liability for the small European country who was involved. It also involved public policy considerations of, first of all, did the state negligently crash a brand new helicopter? And secondly, and perhaps more importantly, did the state negligently run the dispute? Because the tribunal in that case ultimately found that the claim of this European state was time-barred. This raises significant public policy considerations of, did the state in that situation waste state resources? Did it lose the ability to pursue a claim for $60 million simply by sitting on its hands? The arbitration between the oil company and the Middle Eastern state that I mentioned also demonstrates these two factors. Again, we had a claim for billions of dollars, and we have the significant public policy issues of, first of all, did the oil company pollute the Middle Eastern country? And secondly, if it did, who was responsible for cleaning it up? And finally, to end with the hospital arbitration that I mentioned before, again, we have a claim for $500 million, a significant potential liability for the government of South Australia. And again, we have significant public policy issues that arise from a contractual claim. In this case, we have the builder alleging that the delay in the construction of the hospital actually arose from deliberate actions of the government of South Australia. These examples illustrate that the two factors that were mentioned by the UN Working Group when deciding to pursue the Mauritius Convention are present in many contractual arbitrations involving the state. We have the potential huge liability of the state. We have public policy considerations. Indeed, there's an argument that even when those factors aren't present, but nonetheless, if a state is involved, if there is a potential for expenditure of the state, or there is a dispute involving expenditure of the state, then that dispute should be public. Just a couple of weeks ago, here in Adelaide, we had a story in the local newspaper complaining about the fact that the state government had spent a considerable amount of money on buying chairs for the local Yatala prison. And here we have the most simple of contracts between a state and a private party, the contract for the purchase of chairs. And yet even that, according to the local newspaper, raised public policy issues of whether the state was spending more money than it should on chairs for prisoners. Now, to be clear, when identifying these arguments, I'm not taking a position whether or not indeed these disputes should be public or should be confidential. I represent clients who very much rely on the confidentiality of their arbitrations, including state clients. The point is simply that these arguments that have been raised in investment treaty arbitration contexts as to why these disputes should be public can be applied equally to many arbitrations arising from a contract. Now, this issue about whether or not arbitrations arising from a contract between a state and a private party should be confidential or should be public is not new. These issues have arisen since we've had arbitrations between the state and a private party. Indeed, Dr. Kenny mentioned the famous Esso and Plowman decision of the High Court of Australia, finding that there was no implied confidentiality in arbitration. When the High Court reached that conclusion, it relied partly on the public consequences of the dispute at issue. And I'll quote quickly here from Justice Brennan in that decision, where he stated that the award to be made in the respective arbitrations will affect the price of the energy supplied by the appellants and by them to the public. Went on to say that the public generally has a real interest in the outcome and perhaps in the progress of each arbitration. Indeed, academics have also for a long time recognised that there are strong arguments to be made for publicity and disclosure of arbitrations involving state entities, including when those arbitrations arise from a contract. David Cairns, the frequent New Zealand arbitrator, wrote over 20 years ago in the context of New Zealand considering changes to its legislation, which I think was mentioned by Dr. Kenny. He mentioned this need, and again, I'm going to quote from David Cairns because I think it reflects the view of many at the time, when he stated that this facility in arbitration to avoid painful disclosure is perfectly acceptable between private individuals without public reporting responsibilities. It is, however, at odds with the principles of open government expected of public authorities. And he went on to say it is not difficult to imagine a department in some circumstances finding arbitration very attractive as a possible means to bury official mismanagement or a dispute that might be politically painful in a long and conveniently confidential arbitration. And that touches on what I was talking about before with regard to this helicopter arbitration. There we had a European country who had, according to the tribunal, mismanaged the arbitration. It sat on its hands for too long and lost its right to claim damages from the US company that supplied the helicopter. It was very convenient for that European country that that arbitration was confidential and that this mismanagement was never open to the people of that European country. Mr. Cairns went on to conclude that in arbitrations between private parties, an obligation of confidence might remain appropriate. However, this article proposes that a separate standard is required for arbitrations involving the state or public authorities. Once again, I'm not necessarily supporting the view of Mr. Cairns. I'm just stating that in the context that we face today, where we have significant discussion about transparency and confidentiality of disputes involving the states in the context of investment treaties, it seems that perhaps a discussion of those same issues in the different context of arbitrations involving a state arising from a contract might perhaps have been lost. That's the modest proposal that I'm putting forward tonight. And so I think let me now conclude the presentation in two parts. First of all, let me conclude by celebrating that somehow I managed to get through this presentation without a 6-year-old dressed as a skeleton bursting in demanding candy. In fact, I'm going to wrap up quickly before that inevitably happens. And let me also conclude by saying that as we do discuss and debate the role of transparency and confidentiality in investment treaty arbitration, as we necessarily have to, let's not forget the equally important debate about the role of transparency and confidentiality in arbitrations involving the state coming out of a contract. Any questions from the group on my presentation?
I completely, thank you, Nick. Very interesting. I'd like to say that I agree with the idea that even UNCITRAL should be looking at this question of what about confidentiality for contract-based arbitrations with state parties, involving the state party. But I'd like to press you a bit on your argument that the two main arguments apply with equal force compared to treaty-based arbitration. Because first on the monetary impact, like an award against a state under a treaty is going to have potentially, or in fact, a lot more implications, monetary implication, I would say, for the state. Because if you look at India, for example, after it suffered a loss in some cases, well, for one thing, that was involving an Australian investor, a very small case, but suddenly lots of foreign investors from around the world realised that India had signed up to all these treaties and, was allegedly misbehaving, so they all filed claims in different areas. But then some of them involved sort of retrospective tax and so on. And awards came out, and then, you get follow-on cases under that similar treaty or other treaties with similar protection for foreign investors. And so that's different, I think, from an investment contract where there might be a dispute about some substantive contract or matter depend very much on particular wording or response by state or whatever. And the award in that case has no further ripple-on effects. And secondly, you said the other factor is the public policy considerations are important, and I agree, but are they the same as in treaty arbitration? So if a state mismanages a treaty-based arbitration, don't we have a bigger public interest in that as taxpayers or whatever into a contract-based arbitration? And also, if it's a contract-based arbitration, the alternative of litigation might be more inefficient in some ways with appeals and time delays and so on. So we might want to encourage states to look to alternatives to court litigation. In fact, it's part of Commonwealth Government's model litigation policy and so on. So I think there are also competing public policy arguments as well in those contract-based arbitrations which don't match on to the treaty-based arbitration.
Thank you for the question. And I broadly take your 2 points. Dealing with the first one with regard to the monetary implications, a couple of thoughts on that. I mean, first of all, you're right, just looking at the size of the individual claims under investment treaties, they have been higher than the claims under contract arbitrations. I don't think anyone under a contract has faced a $50 billion award like Russia faced under the investment treaty. And I take your broader point that investment treaty claims can arise under a policy and generate many claims. And so while Spain, for example, faces liability of billions of dollars under investment treaties as a result of its energy policy changes a couple of decades ago, most contractual liability is going to be confined to the particular dispute. But I will make the point that nonetheless, the size of the potential liability is massive. The examples that I mentioned before illustrate that. I mean, South Australia at the moment is facing a claim for $500 million, which in the context of South Australia is a significant claim. The dispute between this oil company and the Middle Eastern country, someone had to spend a couple of $1 billion cleaning up the country. And for this Middle Eastern country, this was a huge, unimaginable amount of money. And so you're right, we're perhaps not talking about the amounts of money we might be in investment treaties, especially given the ripple effects, as you say, but we are talking about extraordinary amounts of money. With regard to your second point about public interest, I also take your point that it's a different kind of public interest. Many investment treaty claims arise from a general policy, and so it's squarely the policy that's at issue. Whereas in contractual arbitrations, as you say, the fundamental issue is was there a breach of contract, and the policy issues are going to be peripheral. But nonetheless, significant policy issues arises, as I mentioned, with regard to the hospital arbitration. One of the main arguments of the builder is that it was a policy of the state that actually forced it to breach the contract, and therefore that policy of the state comes front and centre in the contractual dispute. Also, as you're aware, many of the investment treaty disputes proceed in parallel with contractual disputes, and the policy that's being challenged in the treaty dispute is very much a central issue and the contractual issue as well. In sum, I certainly take your point that we're talking about perhaps different types of sums, and we're talking about different kinds of public interest, but I'm not convinced, and I think it would need a broader discussion as to that necessarily means that the public interest and the quantities involved insufficient to suggest that there are arguments for transparency in the context of arbitrations arising from a contract.
Anyone have any questions or any questions online? We have one question from Andrew Luna and asking and wondering where he could find more information or studies on state arbitration.
Sorry, the question where he can find the information with regard to state arbitrations arising from a contract?
Correct. More information. Do you want to add anything, Nick?
The confidential, so.
Investment.
Yes, it's difficult to refer to particular information that's written down, given that the arbitrations are confidential. But I'm happy to share what I can if the person with the question wants to reach out. I'm sure they can get my contact details through the forum.
Perfect. So we will share the contact details of the speakers after we finish the event. Thank you very much, Nick. That was a wonderful presentation. So finally, let me introduce you to our commentator, Associate Professor Jim Huang, a leading authority in international arbitration, conflict of laws, and cross-border digital trade. With her distinguished academic background, Associate Professor Huang has significantly influenced global legal scholarship. Today, she will be providing expert commentary reflecting on transparency and confidentiality in international arbitration and the key themes discussed through the symposium. Thank you. The floor is yours.
Thank you so much. I feel I'm really honored. It is also a great privilege and great burden that I can comment on these 4 distinguished speakers. So my commentation has 2 parts. So the first part is I would like to use 2 keywords to make some very humble summary comments on the 4 distinguished speakers. The last one is a few suggestions. So I think the 2 keywords, again, I'm a conflict of law scholar. So I think the issue is consensual applicable law approach. You apply the law based on parties' consent, consensual approach, versus mandatory applicable law approach. So the consensual approach especially derived from, as Caroline mentioned, that commercial arbitration essentially, fundamentally based on parties' consent, parties' agreement. The mandatory law approach, like Nick repeatedly mentioned about the public policy. Also, our first speaker, Ankita, talked about the origin, also the international momentum that the Mauritius Convention was concluded. So if we go through each speakers, I think our first speaker, Ankita, is really focused on the mandatory applicable law approach. So because if we consider the difference between investment arbitration and commercial arbitration, and the debate is whether the private party, the investor in the investment arbitration, whether it's really based on the contract, or actually it's a treaty between the investment home state and investment host state, and then the investor may be considered as a third party beneficiary. So here the issue is the Mauritius Convention, it demonstrated the state interest, like Australia is one of the 9 parties ratified the convention. Also in related to our second speaker, Professor Nottage's comment, why there is so few countries from Asia to ratify the convention, this may be related to really nothing about the arbitration, it's about the democratic, the system of the Asian countries. So the mandatory approach, it actually go beyond parties' consent. It go beyond the particular investment host state and this particular investor. It really go, it's an overspill of many other issues, like after Philip Morris case, the tobacco issues was carved out in Australian investment treaties. So those mandatory law approach, it demonstrates investment arbitration as a public international law branch. It was impact on the public concerns. And then if we look at the Professor Nottage's presentation, he started from investment arbitration, but actually it's a very good balance. Later he moved to confidentiality. It's an advantage. I think this comment actually, maybe we can consider is more about this is a consensual approach that based on the the law that the party agreed, and they agree that confidentiality is an advantage, and we agree we are going to keep our dispute resolution process, the relevant law and the relevant documents related in this process as private. Let's go to Caroline's points. What does it mean by confidentiality? I really like the point that she mentioned that the distinguishing between publish a judgment concerning enforcement of arbitration award and publish the relevant document like the evidence, parties pleading, leading to the award itself. Because the judgment recognition, use a judgment to enforce the arbitration award. When we move to the litigation, actually we move to the public domain, and we move away the consensual approach. Also regarding Caroline's comments, I really appreciate he talked about like the public, like about efficient dispute resolution. Especially we look at the parties' consent, especially we look at commercial arbitration. I think the confidentiality, it has strong value because it can really help the parties to resolve their disputes efficiently if we do not consider, we do not consider the public concerns if a state involved regarding public monies, regarding the institutional building, and regarding how the system of the arbitration can be more systematic if there is a precedent system like litigation. And then regarding the leak, Nick mentioned really focus on contractual arbitration involved states. I think this is a complex topic because it is an issue it needs a balance. On one hand, we have a contractual arbitration. This is based on consensual approach, but at the same time, we have the state. So when we talk about the states, there is always like the tax money concerns, democratic system. This may also relate to the questions, our online audience ask, where we can find more information about contractual arbitration involving a state. And it is difficult. It also, going back to our first speaker, how far or how soon there will be more countries that ratify the Mauritius Convention and also adopt the UNCITRAL model law, even in contractual arbitration involving states. So my second part is really some very humble consideration. During our four speakers, we talk a lot about the transparency versus confidentiality. Like Caroline, detailed discuss the meaning of confidentiality in different states. And then our first speaker, Anita, talked about the meaning of transparency, in terms of our Mauritius Convention. I would like to add another concept about privacy. Caroline actually mentioned the meaning of privacy. My background a little bit about digital trade and data protection. There are indeed some emerging cases in investment arbitration involve privacy, but it's not the privacy that Caroline mentioned, like the privacy only to exclude the third party. It's more about the personal information protection. The privacy means the personal information protection. Like the cases, Canon Energy versus Canada, like Avato Associated versus Korea. So those cases, provide very interesting conflict of law issues like the connecting factor to which law should be applied to arbitration. So we all know that arbitration is subject to the lex forum. And here the sitters refers to the seat of arbitration. And the place of hearing doesn't matter. However, when you have privacy as a personal information, the place of hearing may really matter, right? When you have personal information of the witness, personal information maybe as the investors, the shareholders, etc. So the place of hearing as a place to process those information, right? So its law may need to be considered, what law that the law of the place of hearing should be applied, to protect the privacy of the information in the arbitration. So I think these are all very interesting questions, especially, when we celebrate the 10 years of transparency. This is really exciting and inspiring. So thank you.
So thank you very much, Associate Professor Wang. I think that was the best way of wrapping up this event. And thank you all for joining us today. The event is now concluded. So I would like to send our thanks to our hosts, UNCITRAL RCAP and the University of Sydney and Sydney Law School. We are also very grateful to our collaborators and organizers, ANCA, UNCITRAL National Coordinating Committee for Australia, and to our generous sponsors, CAPLES, Center for Asian and Pacific Law, and SIL, Sydney Center for International Law. Finally, please join me in thanking all of our speakers tonight. And for those here with us, let's continue the evening with a content reception.